And greetings. Welcome, everybody, to American Jurisprudence, Fraud and Deceit, the Perversion of Truth, and the Violation of Good Faith. Give me one moment here while I double check the audio. Of course. There we go. Now we should be sounding better. Please hit the like if you could, and let's get this thing started here. 1 second here. Get the live chat ready to go. Get this thing off the screen, and we're ready to hit it. Okay, we'll also be assisted with Black's Law Dictionary, and let me zoom this puppy in. So we can see a lot better here. It's better. Center it a bit. And there we go. So we're using 9th edition, so very modern edition. Should be sufficient for anything today that we see in courts. So let's get right down to it. Again, this is just to be for informational, educational purposes. It's not to be construed, misinterpreted, or interpreted as lawful legal advice in any way, shape, or form. You should not perform this for your own use or non-use. It's up to you, so don't do this at home. So, fraud and deceit. Oops, let's get right to it here. All right, there we go. I'm going to zoom this guy in too. Okay, let's get right to it. So, the summary, the scope. This article discusses the general principles of fraud and deceit, the definitions and nature thereof, what constitute actionable misrepresentations and fraud as grounds for damages or equitable relief, and the elements, legal incidents, and effect of fraud, fraudulent representations, concealment, and deceit, including the persons liable, the persons entitled to relief, the remedies available, the measure of damages, the defenses against liability, and matters of practice and procedure in actions therefore. So, we'll go over the federal aspects. Provides that fraud as a defense is to be pleaded affirmatively, while this federal rule of civil procedure states that in all averments of fraud or mistake, the circumstances constituting fraud or mistake must be stated with particularity. There are numerous federal statutes that criminalize the making of false statements in particular contexts, or that preclude participation in federal programs or funding where a fraudulent or false claim has been made in the application or other related aspect. So that's some federal aspects of this. And then treated elsewhere, we have things like annulments of marriages, accountants, architects, dispute resolution, alternatives, bankruptcy bills and notes, brokers, cancellation of instruments, burglary, compromise, settlement, trust, contracts, drugs, controlled substances, fraudulent conveyances and transfers, which will be another episode, corporations, false pretenses, divorce separations, deeds, duress, undue influence, criminal law. So none of these apply here. False personation, false pretenses, forgery. So we're not going to be going over any of those on this one. All right, we have Chosen in the house. Glad to see everyone's here. We're getting here. Seems like, let me refresh this thing here. It shows me that nobody's here. I know that can't be true. Yeah, it shows that nobody's here. That's weird. Okay, guys. Well, let's continue here. So now we're getting into the good stuff here. General definitions. Yeah, it says one in here. That's really strange. Why is there only one person in here? Oh, okay, so this will be where we start here is the general definitions. All right, you have rights, cops have... Okay, so the count's wrong. That's really strange. Odd. All right, let's get right to it. There's some pretty good references here. Yeah, more than one, definitely. But we're not going to go over any of this stuff today. Computer crimes, Vermont's computer crime statute. So a lot of this stuff has computer crimes involved in this. So let's think about that. These are 2010, 2008. These are pretty good references here. Let's continue. Fraud and misrepresentation cannot be defined easily because they can be accomplished in so many different ways. However, they present issues of fact. In addition to circumstantial evidence, motive, past conduct, and related... Oh, shit. We good here? Put two cause we are mentioning. Oh, I see it there. Cool. Okay. So, all right. Sorry about that. In addition to circumstantial evidence, motive, past conduct, and related wrongful acts are factors to be considered by the trial court in examining whether a claim for fraud exists. So, in addition to circumstantial evidence, we have motive, past conduct, and related wrongful acts as factors to be considered by the trial court in examining whether a claim for fraud exists. And that's footnote 2. The term fraud is a generic one, which embraces all the multifarious means resorted to by one individual to gain advantage over another by false suggestions or by suppression of the truth. Fraud, a peculiar species of falsity, is the intentional misrepresentation of a material fact made for the purpose of inducing another to rely on which the other reasonably relies to his or her detriment. Make sure we get this centered here on the screen. There we go. Fraud consists in deception practiced in order to induce another to part with property or surrender some legal right, and which accomplishes the end designed. The tort of fraud is defined as the willful misrepresentation of a material fact made to induce another to act upon which such person acts to his or her injury. An essential element in every fraud action is a finding that the representation was made with the intention and purpose of deceiving the opposite party, and for the purpose of injuring him or her. Fraud involves a misrepresentation or suppression of the truth, made with the intention either to obtain an unjust advantage for one party or to cause a loss or inconvenience to the other. It is defined generally under the common law as an intentional perversion of truth in order to induce another to act in reliance upon it. Let's read this again. An intentional perversion of truth to induce another or to act in reliance upon it. Fraud consists in anything calculated to deceive, whether by a single act or combination, or by suppression of truth, or a suggestion of what is false, whether it be a direct falsehood, or by innuendo, by speech or silence, word of mouth, of look or gesture. It is practiced when the deception of another to his or her damage is brought about by a misrepresentation of fact or by silence when good faith required expression. Fraud is the intentional misrepresentation of a material fact made for the purpose of inducing another to rely and on which the other reasonably relies to his or her detriment. The gist of fraud is successfully using cunning, deception, or artifice to cheat another to the other's injury. Every fraud in its most general and fundamental conception consists of the obtaining of an undue advantage by means of some act or omission that is unconscientious or a violation of good faith. Fraud has also been defined by the courts to mean, all right, let's get ready for this list, guys. I hope you have your number 1 Esquire or number 7 Esquire pen ready here. Do we have anyone else here in the chat that can say hello and want to pose any questions at this point before I go down this laundry list here? All right, well, I know this takes a little while for the delay to get through. Let me check the stream quality and see how things are coming through this end. Check the stream quality. Looks like we're doing good. All right, guys, let's proceed then. So here's our laundry list of what the courts have defined fraud to mean. Deceitful practices in depriving or endeavoring to deprive another of his or her known right by means of some artful device or plan contrary to the plain rules of common honesty. An instance or act of trickery or deceit, an act of deluding, or an intentional misrepresentation for the purpose of inducing another to rely upon it to part with some valuable thing. An intentional perversion or concealment of the truth for the purposes of inducing another, in reliance upon it, to part with some valuable thing or to surrender a legal right. Any cunning, deception, or artifice used in violation of a legal or equitable duty to circumvent, cheat, or deceive another. Any artifice by which a person is deceived to his or her disadvantage. An act or omission or concealment in breach of a legal duty, trust, or confidence justly imposed, when the breach causes injury to another or the taking of an undue and unconscientious advantage. Anything falsely said or done to the injury of the property rights of another. All surprise, trick, cunning, dissembling, and any unfair way by which another is cheated. Any act designed to gain an unfair advantage over another. A deceit, trick, or an artifice by which the right or interest of another is injured. Anything that is calculated to deceive, whether it is a single act or a combination of circumstances, or acts or words that amount to a suppression of the truth, or mere silence. Fraud, therefore, in its general sense, is deemed to comprise anything calculated to deceive, including all acts, omissions, and concealments involving a breach of legal or equitable duty, trust, or confidence justly reposed, resulting in damage to another, or by which an undue and unconscientious advantage of another is taken of another. The hallmarks of fraud are misrepresentation or deceit. Fraud is a term of art naming a common law cause of action. All right, guys, beautiful stuff. Are you all here? Is anyone still here? Observation. Equitable fraud is separate from and broader than common law fraud. The flexibility of the doctrine of equitable fraud is necessary to allow courts of equity to address fraud in all of its forms, unhampered by the formalism that traditionally limited the common law courts. All right. You have cops. You have rights. Cops have duties. Glad to see you're still here. All right. So our cumulative supplement here, cases. In the context of common law fraud, remember the common law fraud, right, is less broad than the equitable fraud. The problem with this is hard enough just to get a common law court, but an equitable court is getting to be more difficult too as they try to trick people out of the venue. They say it's the proper venue. All right. Oops, what happened here? I didn't like that statement. Give me a moment here. Oops, sorry. One more second here. You know, sometimes this pisses me off. Let's see here. Refresh. Come on. There we go. All right, we're back. . Okay, so we just went down this nice laundry list here. Where'd it go? And we're going on these cases here. So again, the common law is less broad than the equitable law in these cases. So let's continue. In the context of common law fraud, actual fraud stands in contrast to implied fraud or fraud in law, which describes acts of deception that may exist without the imputation of bad faith or immorality. Common law fraud connotes deception or trickery generally. Interesting. Common law fraud connotes deception or trickery generally. The elements of an action in fraud under Ohio law are 1. False representation concerning a fact. 2. Knowledge of the falsity of the representation or utter disregard for its truthfulness. Intent to induce reliance upon the representation. Justifiable reliance upon the representation. And 5, injury proximately caused by the reliance. So, again, once we start getting down into state statutes and law and such, it gets a little bit harder to read than the principles of common law of American jurisprudence. So let's break this down. A false representation concerning a fact. So this would have to be a substantial fact that could be entered as evidence that has been falsely represented. Knowledge of the falsity of the representation or utter disregard for its truthfulness. So that's when there's a knowledge of a falsity or the utter disregard for the truthfulness and just take it and run with it, even though they know it's false. Intent to induce reliance upon the representation. So they try to say, well, trust me, it's good. You have to do it this way. Justifiable reliance upon the representation. Well, they have authority. They told me I should do it, so I did it. Injury proximately caused by the reliance. So this seems a little bit more involved with other aspects now. Particular aspects of fraud would vary, and see as you get to a state, and they use Ohio as an example here with some cases, that you will find there's finer and finer things involving the law that apply differently from state to state. And we can see all these are cases here. So there's no other supplements here. All right. That's it. A lot of cases, though. All right, let's proceed here. Fraud in the inducement. Fraud in factum distinguished. Fraud encompasses, among other things, the theory of fraudulent inducement. Now, we all know what inducement means, but let's look at more closely what it means in context of the law, in the legal context. So let's check our friend Black's Law Dictionary here and find where they define inducement and see how that comes. Moment here. And check this. We got to go to Black's Law. Right. Now we're going to go to the right page for what we're looking for here. Inducement. Let's see. Where are we going to be here? CF. Bear with me a moment here as I look through. It'll be a lot quicker if I scan it here than... Okay, it's gone past it. It's hard because it pulls up every instance of the stupid word. So it doesn't matter where I go in the list. I don't know what it is until I look at it. And then you see the heading. Induce. All right, this should be it here. Insanity defense. All right, innuendo. Innuendo is an excellent one too. We'll check that out too because that came in here as well. So that's 89 and 873. Okay. Inducement, the act or process of enticing or persuading another person to take a certain course of action. There's active inducement, the act of intentionally causing a third party to infringe a valid patent. So proof actual intent to patent infringement. So contracts, the benefit or advantage that causes a promisor to enter into a contract. Criminal law, an enticement or urging of another person to commit a crime. The preliminary statement in a pleading, especially in an action for defamation. The plaintiff's allegation that intrinsic facts gave a defamatory meaning to a statement is not defamatory on its face or in a criminal indictment. The statement, okay. So innuendo, again, that's another good word. Let's look at that real quick while we're here with Black and see. Jeez, come on. All right. So innuendo, Latin, 17th century, by hinting. An oblique remark or indirect suggestion, usually of a derogatory nature. An explanatory word or passage inserted parenthetically into a legal document. In criminal law, an innuendo is a statement in an indictment showing the application or meaning of matter previously expressed, the meaning of which would not otherwise be clear. It's a statement in an indictment. Interesting. In the law of defamation, an innuendo is the plaintiff's explanation of a statement's defamatory meaning when that meaning is not apparent from the statement's face. For example, the innuendo of the statement, David burned down his house, can be shown by pleading that the statement was understood to mean that David was defrauding his insurance company, the fact that he had insured his house and is pleaded and proved by inducement. Got you. So we got that. So let's continue here. Whenever I see this in set paragraphs in blacks, you got to read this stuff because they used to have it in everything in first edition. Now they have it, I guess it's just cream. Innuendo, from innuo, to nod or beckon with the head, is a word used in declarations and law pleadings to ascertain a person or thing which was named before. If a man say that such a one had the pox, innuendo, the French pox, this will not be admitted because the French pox was not mentioned before, and the word shall be construed in a more favorable sense. But if in discourse of the French pox one say that such a one had the pox, innuendo, the French pox, this will be admitted to render that certain which was uncertain before. So the context of the conversation can allow what we would call a synecdoche, right? So let's continue here. It is not a true innuendo to repeat the obvious meaning of defamatory words in other language or in an embroidered or exaggerated way. Otherwise, an ingenious pleader could perplex the judge and jury and harry the defendant by ringing the changes on the same words, creating numerous different causes of action, each requiring a separate verdict. A true innuendo relies on a conjunction of the words and some intrinsic fact. So you have to have a conjunction of the words used and some intrinsic fact. Does this make sense? A true innuendo relies on a conjunction of the words used and some extrinsic fact, a fact that has nothing to do with these words. Thus, It is defamatory in itself to say that a man's affairs are being investigated by the fraud squad, but the statement does not support the innuendo that those affairs are being carried on fraudulently. Conversely, the statement, X is a good advertiser, is innocent in itself, but carries a libelous innuendo if published to persons who know the extrinsic facts that X is an eminent member of the bar. Wow. Lawyers' advertising no longer has relevance to American law. Example. Well, okay, so interesting digression. Let's get back to the studies. So we were right here. Oh, shoot. Why did it do that? Let me fix this real quick. That's why. Okay. Just a moment here. Come on. One more time. Oh. Interact. Nope, one more time. Gosh darn it. There we go. Okay. Now we're there. All right, where we go? All right. I think that's where we left off here, 31, yep. All right. So, fraud in the inducement, fraud in factum distinguished. So let's get back. Fraud in the inducement, which is a subset. Let's see, a claim of fraud in the inducement arises when a party is induced to enter into an agreement through fraud or misrepresentation. The fraud relates not to the nature or purport of the contract, but to the facts inducing its execution. Facts inducing its execution. Fraud in the inducement, which is a subset of the tort of fraud, occurs when the promisor knows what he or she is signing, but his or her consent is induced by fraud. When mutual assent is present and a contract is formed, which, by reason of the fraud, is voidable. A tort of fraudulent inducement means that one has been led by another's guile, surreptitiousness, or other form of deceit, to enter into an agreement to his or her detriment. Fraud in the inducement goes to the means used to induce a party to enter into a contract, and in such cases, the party knows the character of the instrument and intends to execute it, but the contract may be voidable if the party's consent was obtained by false representations. So there's the key. To state a claim for fraud in the inducement, the party must allege 1. A material representation of a presently existing or past fact. 2. An intent to deceive. 3. Reasonable reliance on the misrepresentation. And 4. Resulting damages. So, let's allege all of these, it looks like. Fraudulent inducement is a type of fraud that occurs when material false representation is made and 1. Was known to be false when it was made. Now that's key there. When it was made. It was known to be false, was intended to be acted upon, was relied upon, and caused injury. To prove fraudulent inducement, a plaintiff must establish 1. A false representation concerning a fact, or in the face of a duty to disclose, concealment of a fact material to the transaction. 2. Knowledge of the falsity of the representation or utter disregard for its truthfulness. 3. Intent to induce reliance upon the misrepresentation. And 4. Justifiable reliance upon the representation under circumstances manifesting a right to rely. And 5. Injury proximately caused by the reliance. This looks like from the Ohio Code. Let me look at this real quick. Yep, Ohio law, sure enough. Fraud in the factum, as distinguished from fraud in the inducement, means either fraud in the substitution of documents or fraud in the obtaining of execution or delivery. So, as we can see here, that fraud in the factum is pretty straightforward, but fraud in the inducement requires all these factors: material representation, intent to deceive, reasonable reliance, all these things. Okay. On our cumulative supplement, we have some cases here under Indiana law. To prove fraudulent inducement, a party must demonstrate a false material representation of facts that was made with knowledge or reckless disregard of its falsity, with an intent to deceive, and that the party reasonably relied upon the misrepresentation, which was the proximate cause of its injury. Okay, so there it is, 7th Circuit, 2013. And here's all the good stuff here, stating if it were shown that there is fraud in the execution of the instrument itself, that person was induced to sign it from what it understood to be, there's no agreement in fact existed, the fraud would lie in the factum. Promised by the grantee on delivery of the deed to pay the purchase money on the following day, 1910. And as to the effect of fraud on the validity of a deed, generally see deeds, which we have gone over here as well. Section 160. Okay, so that's another one there. One second here. Okay. On to section 3. Good and bad faith. Relation to fraud. Good faith is defined as an honest intention to abstain from taking any unconscientious advantage of another, even though the forms and technicalities of law, together with an absence of all other information or benefits of facts, would render the transaction unconscientious. Bad faith is, of course, the antithesis. And although it is an indefinite term, it differs from and is stronger than the idea of negligence, in that it contemplates a state of mind affirmatively operating with a furtive design, with some motive of self-interest or ill will, or for an ulterior purpose. There seems to be little difference between bad faith and fraud in this particular relation. Fraud may be said to be an action of a more affirmative evil nature, such as proceeding or acting dishonestly, intentionally, and deliberately, with a wicked motive to cheat or deceive one party to a transaction with respect to the situation or operations, or such as an action that results in his or her damage or loss and to the advantage or gain of the other party. In some jurisdictions, bad faith has been held to be the test of fraud. Thus, an honest mistake does not rise to the level of bad faith required to sustain a cause of action for fraud. However, in some jurisdictions, the view has been expressed that while under circumstances the word fraud is synonymous with bad faith, the concepts of bad faith and fraud are generally separate and distinct, requiring the allegation and proof of different elements. Hope that's clear there. Depending on your jurisdiction, this is what I love about American jurisprudence, is that they're very broad in defining the general principles and intent behind the laws, and then guide you to where you'll find distinctions between statutes and such. So let's continue here. Observation. Actual fraud involves moral turpitude and does not include fraud implied in law, which may exist without the imputation of bad faith or an intentional wrong. Okay, so actual fraud has some moral factors, right, that do not exist, which may not exist without the bad faith or intentional wrong. So let's continue here. We're on to deceit, section 4. Deceit is a species of fraud. Deceit, at common law, was and is essentially fraud, that is, a deliberate effort to obtain something of value by deceiving another. In some jurisdictions, conduct prohibited under separate statutory definitions of fraud and deceit is substantially identical. Deceit is actual fraud, and it consists of any false representation or contrivance whereby one person overreaches and misleads another to his or her hurt. Deceit excludes the idea of mistake, and fraud has been termed a grosser species of deceit. The tort of fraudulent deceit results from either a willful or reckless misrepresentation or suppression of material facts with an intent to mislead. Observation. The term fraud applies when there is a contract between the parties, while the term deceit applies when there is no contract between the parties. You guys got this? The term fraud applies when there is a contract between the parties, while the term deceit applies when there is no contract between the parties. In some jurisdictions, there is no separate cause of action for deceit, and deceit is encompassed within a fraud claim. Okay, so there it is. Good stuff here. Let's continue here to collusion. Collusion is an agreement between two or more persons to defraud another of his or her rights by the forms of law or to secure an object forbidden by law. Collusion, as far as the law is concerned, has been deemed to be a species of fraud, just like deceit is. Criminal fraud, section 6. Fraud need not be a criminal act, although there are many fraudulent actions which have been criminalized by statute. Cases. There is no cognizable property interest protected under the bank fraud statute in the ethereal right to accurate information. So nothing criminal there. 2021, so very current stuff in the U.S. Circuit of Appeals there, it looks like. Okay, so there's a crimes involving fraud or false statements as use of fraud and trick to gain entry as constructive breaking for purposes of prosecution for burglary. Okay. Wow. Section 7. False representation, misrepresentation, concealment, and false pretenses. Hey, we got someone here in the house. James Allen, welcome. Salute. De facto equals deed, a mask act as our de jure from government, but all their, I gotta read this for you, but all their actions are fraud. All these contracts and adhesive contracts, never giving full disclosures, meeting of the minds. You are very correct, and we're actually going to get onto that here because this is all covered here in American jurisprudence in this particular volume here. So let's continue. This is again fraud, false misrepresentation, false representation, misrepresentation, concealment, and false pretenses. Whew. Fraud may consist of both active misrepresentation and passive silence. Fraud can be passive silence. Most fraud cases are based on either false representations of material facts or concealment of material facts. Indeed, actionable fraud has been said to be the concealment of a fact that should have been disclosed, or the representation of the existence of a material fact that did not exist. False may mean untrue, or it may mean designedly untrue, implying an intention to deceive, as where it is applied to the representations of one inducing another to act to his or her own injury. Fraudulent representations are those proceeding from or characterized by fraud, the purpose of which is to deceive. A representation within the meaning of the law of fraud is anything short of a warranty that proceeds from the action or conduct of the party charged and is sufficient to create upon the mind of a distinct impression of fact conducive to action. Observation. An intentional misrepresentation is generally an element of fraud, although the terms fraud and intentional misrepresentation are often used interchangeably in common parlance. A court has recognized the potential viability of a claim of intentional misrepresentation in a case where a doctor misrepresented his or her qualifications to a patient. So there you go, intentional misrepresentation. So there it is. A misrepresentation is a misstatement of fact, and has been said to be that which, if accepted, leads the mind to an apprehension of a condition other than different from that which exists. A misrepresentation is an assertion that is not in accord with the facts. And for the purposes of a fraud claim, a misrepresentation is a falsehood or untruth with the intent and purpose to deceive. Misrepresentations, as you say here, a lot of these things are misrepresentations if you can articulate it as such, and that's what we're learning to do right here. Where distinctively used, misrepresentations may be said to import a positive and false statement as to the subject matter of a transaction. Concealment implies to the non-disclosure of some fact which should be revealed. And false pretenses means any trick or device whereby the property of another is obtained. This statement here actually applies to a lot of things very broadly now that James mentions what he does here when you start to think of this. Everything from fines and fees to deeds. As the offense of obtaining money or property by false pretenses, see false pretenses. So great, we have a whole other volume on that with American jurisprudence. So now we're on to Section 8 of actual fraud. Fraud is broadly classified as either actual or constructive. Okay, so two kinds of fraud, actual or constructive. To constitute positive or actual fraud, there must be such fraud as affects the conscience. Wow. That is, there must be an intentional deception. In other words, active and positive fraud includes cases of the intentional and successful employment of any cunning, deception, or artifice to circumvent, cheat, or deceive another. A statute may define actual fraud as any of the following acts committed by a party to the contract, or with his or her connivance, with intent to deceive another party thereto, or to induce him or her to enter into the contract. 1. Here it is. The suggestion as a fact of that which is not true by one who does not believe it to be true. 2. The positive assertion in a matter not warranted by the information of the person making it, of which is not true, though he or she believes it to be true. Okay, so the positive assertion in a manner not warranted by the information of the person making it, of which that is not true, though he or she believes it to be true. So just because you believe it to be true is not going to protect you from fraud. Suppression of that which is true by one having knowledge or belief of the fact for a promise made without any intention of performing it or any act fitted to deceive. So, any asks another party thereto to induce him or her to enter into the contract. It's a long sentence. A statute may define actual fraud as any of the following acts committed by a party to the contract. Okay. That's a good long sentence there. Observation. Actual fraud cannot be predicated upon facts which a party has a right by law to do, nor upon the non-performance of act which by law he or she is not bound to do. Actual fraud is embraced generally under two categories: suggestion of falsehood or false representation, and suppression of the truth or concealment. Actual fraud usually involves dishonesty of purpose or intent to deceive, and is distinguished from constructive fraud, involves the element of deceit practiced upon the party defrauded. The difference between actual fraud and constructive fraud is primarily the type of conduct that may be treated as fraudulent, such as a failure to disclose material facts within the knowledge of the fiduciary. Furthermore, the reliance element is relaxed in a constructive fraud to the extent that reasonable reliance may be presumed on the misrepresentation or non-disclosure of the fiduciary, absent direct evidence of lack of reliance. Remember, the fiduciary is your commitment to do it in the best interest. Absent direct evidence of lack of reliance. Also, constructive fraud differs from actual fraud in that it is based on a confidential relationship rather than a specific misrepresentation. Constructive fraud from actual fraud. Confidential relationship rather than specific misrepresentation. Other jurisdictions describe the difference otherwise, stating that the fraud is the same whether it is actual fraud or constructive fraud, the distinction being in the nature of the relief rather than the character of the fraud. There you go. So, observation. In some jurisdictions, an action for fraud may be either legal or equitable in nature. Also, innocent or constructive fraud exists only as an equitable doctrine and will not support an action for tort damages. Ta-ha! So if you're looking for tort damages, you don't want to make a case for innocent or constructive fraud. You'll only get your injunctions or other kinds of remedies. So in some jurisdictions, an action for fraud may be either legal or equitable. So if you're looking for tort damages, you want to be able to try to present a legal case for fraud. Cumulative supplement. The word actual has a simple meaning in the context of common law fraud, denoting any fraud that involves moral turpitude or intentional wrong. In the context of common law fraud, anything that counts as fraud and is done with wrongful intent is actual fraud. That's that one there, and we're on to constructive or legal fraud. So let's get this one defined. Whew. All right. Constructive fraud includes any act, statement, or omission which amounts to positive fraud or which is construed as a fraud by the courts because of its detrimental effect upon public interest and public or private confidence. Constructive fraud encompasses those breaches which the law condemns as fraudulent merely because they tend to deceive others, violate confidences, or cause injury to public interest, the actor's mental state being immaterial. Wow. So that's constructive fraud. Encompasses those breaches which the law condemns as fraudulent merely because they tend to deceive others, violate confidences, or cause injury to public interest. So constructive fraud is a breach of the legal or equitable duty which the law declares fraudulent because it violates a fiduciary or confidential relationship. It does not necessarily involve any moral guilt, intent to deceive, or actual dishonesty of purpose. It may be defined as any breach of a duty which gains an advantage for the actor by misleading another to his or her prejudice. Unlike actual fraud, constructive fraud requires neither actual dishonesty nor intent to deceive, being a breach of legal or equitable duty, which, irrespective of the moral guilt of the wrongdoer, the law declares fraudulent because of its tendency to deceive others. Constructive fraud consists of 1. Any breach of duty that, without an actual fraudulent intent, gains an advantage to the person in fault or anyone claiming under the person in fault by misleading another person to that person's prejudice or to the prejudice of anyone claiming under that person, or 2. Any act or omission that the law especially declares to be fraudulent, without respect to actual fraud. You have rights, cops have duty. Are you still in the house here? Just curious who's still here because my count seems a bit off. Constructive fraud may consist of a breach of a confidential relationship, which may arise where one person trusts and relies on another, whether the relationship is moral, social, familial, or merely a personal one. All right, we got some people here. Thank you. It may be found where it can be demonstrated that one party has obtained some benefit from the other through undue influence or breach of a fiduciary or confidential relation. In its generic sense, constructive fraud comprises all acts, omissions, and concealments involving a breach of legal or equitable duty, trust, or confidence that results in damage to another. Constructive fraud is also defined as an act done or omitted that amounts to positive fraud or is construed as a fraud by the court because of its detrimental effect upon public interest and public or private confidence, even though the act is not done or omitted with an actual design to perpetrate positive fraud or injury upon other persons. Otherwise stated, constructive fraud arises by the operation of law from a course of conduct which, if sanctioned by law, would secure an unconscionable advantage, irrespective of the existence of the evidence of an actual intent to defraud. So there it is. Unconscionable is a key word here. Let's look this one up here also, because this is a important word I believe we should look at in blacks. Give me a moment here to let's see if we can find it quickly. Fiduciary. Well, you know what? Here's a good one too. It's actually in this one. So let's look at this first, because this is going to help us also get into this definition here. So we mentioned fiduciary, and it's actually got quite a etymology to it. So fiducia comes from the Latin and entrusting, from Roman law, an early form of transfer title by way of mortgage deposit, etc., with a provision for reconveyance upon payment. So fiducial is of relating to, characterized by confidence in or reliance on another person or thing. 16th century. Of or relating to or characterized by confidence in and the reliance on another person or thing. Fiducial relationship. So fiduciary, 17th century. A person who is required to act for the benefit of another person on all matters within the scope of their relationship. One who owes to another the duties of good faith, trust, confidence, and candor. Corporate officer is a fiduciary to the corporation. 2. One who must exercise a high standard of care in managing another's money or property. Okay. Let's see what we got here. James Allen. I got to read this one out because it doesn't fit on the screen. I got to figure this out here. Give me a second. See if I can figure out why this ain't fitting. Hang on a second. Oh, it's locked. There we go. See if I can figure out why it's doing that. Oh, it's really strange. Let's see here. Oh, wait, you know what? I'm going to try a little trick here, see if this will work. Give me a second, guys. Just bear with me one moment. Let's see if this will work better. All right. Let's see if this will work here. Oh, shit. Didn't do it? Oh, come on. Really? Give me a moment here, guys. Shit. One second. Copy it. Okay, here we go. All right. And let's see if there's any different here. Come on, refresh. All right. Black clicking noises. Yeah, that's me and the mouse here having fun. Why isn't this loading up here? Come on. This refresh cache current page. And I still don't see it. Am I on the right one? Yeah. Oh. Let me try this one more time here. Okay, that's there, and see how this one looks here. I still can't. No, it's no different. I'll figure this out another day. Okay. Sorry about all that. It's all done now. So let's continue here. Fiduciary is a vague term and has been pressed into service for a number of ends. My view is that the term fiduciary is so vague that plaintiffs have been able to claim that fiduciary obligations have been breached, when in fact the particular defendant was not a fiduciary stricto sensu, but simply had withheld property from the plaintiff with an unconscionable manner. Okay, that's it there. So we get that one down, and we are actually looking up another word. Move on here. Let's get back to that. Unconscionable. Wait a second here. Unconscionable. There we go. Let's see. Is that? Yes. 1692. All right. Unconscionable. Unconscionable. 16th century. Of a person having no conscience, unscrupulous, an unconscionable used car salesman. Of an act or transaction showing no regard for conscience, affronting the sense of justice, decency, or reasonableness. The contract is void as unconscionable. So we have unconscionable agreement. So all these things here. So unconscionable is a nice substantive unconscionability. Is unconscionability resulting from an actual contract terms that are unduly harsh, commercially unreasonable, and grossly unfair given the existing circumstances. So that makes sense there too. All right, let's see if there are any other great, procedure unconscionability. Oh, wow. Conscionability. So what were we reading here? Oh, unconscionable. All right, so let's read this one here. Extreme unfairness, parties' lack of meaningful choice, contractual terms, principle that court may refuse to enforce a contract is unfair or oppressive because of procedural abuses during contract formation because of overreaching contractual terms, especially terms that are unreasonable or favorable to one party while precluding meaningful choice for the other party. Because unconscionability depends on the circumstances of the time the contract is formed. A later rise in market price is irrelevant. All right, so let's read this here really quick. Traditionally, a bargain was said to be unconscionable in an action at law if it was such that no man in his senses and not under delusion would make, on the one hand, and as no honest and fair man would accept on the other. Damages were then limited to those which the aggrieved party was equitably entitled. Even though a contract was fully enforceable in an action for damages, equitable remedies such as specific performance were refused where the sum total of its provisions drive too hard a bargain for a court of conscience to assist. Modern procedural reforms have blurred the distinction between remedies at law and in equity. For contracts for the sale of goods, Uniform Commercial Code states that the rule of this section without distinction between law and equity. Okay, so comment 1 to that section adds a principle is one of the prevention of oppression and unfair surprise. Well, that's good. And not of disturbance of allocation of risks because of superior bargaining power. So it's a restatement of contracts. Nowhere among the UCC's definitions is there one of unconscionability. That the term is incapable of precise definition is a source of both strength and weakness. So back here we are at a term of art. Excellent. Excellent digression. Thank you for joining me on that. Let's get back to the Amjur. So some jurisdictions recognize, we already read this, right? Let's read this again because the observations are always good. A distinction which may be found between the terms constructive and legal, as applied to fraud, is that a breach of fiduciary relationship or of a contract. Oh, shit. Let's figure out what this means. Can't even say that. All right, there it is. 396. Oops. Okay. Okay, there we go. Contract. Shit, what was it called again? There it is. You bury me fidei. Shit. You bury me fidei. Uberami fidei. Contract uberami fidei. A contract in which the parties owe each other duties with the utmost good faith. Wow. Insurance. In a certain restricted group of contracts, good faith is peculiarly necessary owing to the relationship between the parties and in the cases known as contracts uberami fidei. There is a full duty to disclose all material facts. The typical instance of such contracts is the contract of insurance. Here, the duty is to disclose all material facts to the insurer arises from the fact that many of the relevant circumstances are within the exclusive knowledge of one party, and it would be impossible for the insurer to obtain the facts necessary for him to make a proper calculation of the risk he is asked to assume without his knowledge. So, contract uberami fidei. Uberami fidei. Shit, that's hard to say. Oops, let's see, wrong one. Let's try and get this up here. Wow, this thing's a little bit behind here. Give me a second, guys. Let me get back to the Amjur here. And there we are. And direct. And waiting for this chat to get back. Come on. There we go. There we go. Okay. And there we go. All this admiralty controlled by Vatican, IMF, Universal Postal Union, UN. Yeah, UN. Too much on there, isn't it? A system of debtors and creditors. Christ's creditors. He paid debts or sin, past, future. Yeah. Well, it's a debtor system, isn't it? There is no money. There's only debt in their system. Money is created by your own exertions. Money is land, it's skill, it's wisdom. All right, let's move along here. Uberami fidei. Contract uberami fidei. It's a breach of fiduciary relationship, or a contract of uberami fidei is usually called constructive fraud, whereas the term legal fraud is generally used to characterize a misrepresentation made without knowledge of its falsity. Constructive fraud merely extends tort liability to recklessly false statements. Nice. So constructive fraud. Some jurisdictions recognize that constructive fraud may arise in a buyer-seller relationship where 1. The seller makes unqualified statements to induce another to make a purchase. 2. The buyer relies upon such statements. And 3. The seller has professed to the buyer that he or she has knowledge of the truth of those statements. And here we have our cumulative supplements cases. Under Virginia law, constructive fraud differs from actual fraud in that the misrepresentation of material fact is not made with intent to mislead, but is made innocently or negligently, although resulting in damage to the one relying on it. And that was the West District of Virginia, 2014, so it's rather recent. Let's see if there's anything else here. Nothing else looks like on this one. Just cases. Excellent. Then we have intrinsic, section 10, intrinsic and extrinsic fraud. Fraud may be either extrinsic or intrinsic. In judicial, interposition will, at times, be governed by the court's determination as to which type of fraud has been established by the proof. Extrinsic or collateral fraud is defined as actual fraud, such that there is, on one part of a person chargeable with it, the malus animus, since the mala mens puts itself in motion and acts in order to take an undue advantage of some other person for the purpose of actually and knowingly defrauding him or her. So the malus animus is, second here, that's 1073. Second here, let's go to this. 1073. Okay. Malum, where is it? Animus. Oh, there's malus animus. Latin. Scots law. Bad intention. This intention, coupled with a prohibited act carrying it out, resulted in a crime. So there it is. It's bad intention. Okay, so, and the malamens. Just one there. Malamens, come on. Let's see, 1073. Is that it? Give me a second here. 1073. Same page. It's on here somewhere. Did I miss it? Oh, it's up here. Okay, yeah, it gave me the wrong page. Jurisprudence. Okay, here we go. Jeez. Well, I thought it was here, but I don't see it. Am I missing something here? All right, so it's not there. We'll find it in another place in here. There's got to be a better way to find it. Wow, it's really odd it's not in there. We could look at this 843 and see if there's something on that on it. I had to share about the malamens. Oh, the fault. Okay. Bad fault. Okay, so you filled out 56 IRS fiduciary duties under Act. Myself, I as beneficiary can appoint anyone to control trust. I appoint Secretary of Treasury to handle book for IRS. I'd like to hear more about that. That sounds pretty interesting there. Fiduciary duties under 1956 power of appointment. All right, let's get back to this. So we have our malamens puts itself into a motion and acts in order to take undue advantage of some person. So some bad intents here, right? For the purpose of actually and knowingly defrauding him or her. As applied to fraud, the term intrinsic usually means that fraud was practiced in procuring the transaction, as distinguished from extrinsic fraud, which ordinarily means that fraud was practiced in the act of obtaining a judgment in the course of litigation involving a transaction. Otherwise stated, intrinsic fraud means fraud that induced a party to default or to consent to a judgment against him or her. Extrinsic fraud is actual fraud, but it is collateral to the transaction in litigation. So there we go. So a distinction is also made between extrinsic and intrinsic fraud in the right to bring an action for perjury or false evidence. The rule generally being that while no action will lie for perjury alone, it will lie where an independent or extrinsic fraud has been practiced in connection with the perjury. Accordingly, where the giving of false testimony is only a part of the carrying out of a scheme to defraud the plaintiffs by means of a combination, fraud and deceit of the defendants, an action for damages will lie. So there it is. So where giving of false testimony is the only part of the carrying out of a scheme to defraud the plaintiff by means of combination, fraud, and deceit of the defendants, and an action for damages will lie. So there we go there on that one, and other actions as within definition. So we have a few other here, so let's look at these real quick. Overreaching is tricking, outwitting, or cheating a person into doing an act which he or she would not otherwise have done, and is generally synonymous with fraud, overreaching. Unfair competition is another species of fraud, but this is covered in another article. Promissory fraud is a promise made without any intention of performing it. Observation: the fraud exception to the parole evidence rule does not permit parole evidence of promissory fraud if the evidence in question is offered to show a promise which contradicts an integrated written agreement. Rather, the evidence must tend to establish some independent fact or representation, some fraud in the procurement of the instrument, or some breach of confidence concerning its use, and not a promise directly at variance with the promise of the writing. Parole evidence. So we all remember what that means, right? So let's look at this real quick. So I've given it to you off the top of my head. Jeez. Just a second here. Okay. All right, and we have here parole. Oral. Unwritten. Oral. Interesting, huh? Ancient pleadings were conducted in court orally, and the whole pleadings were called the parole. Okay, there it is. So the spoken evidence, the parole evidence rule does not permit parole evidence of promissory fraud if the evidence in question is offered to show a promise which contradicts an integrated written agreement. Rather, the evidence must tend to establish some independent fact or representation, some fraud in the procurement of the instrument, or some breach of confidence concerning use, and not a promise directly at variance with the promise of the writing. Corruption and fraud are not the same, nor is fraud necessarily included in every instance of corruption. Fraud and undue influence are not equivalent terms. Undue influence may be a species of fraud, or it may exist without any positive fraud. In order to prevail on a claim of undue influence, the following must be proven. 1. Opportunity to control. 2. A condition permitting subversion. And 3. Activity on the part of the person charged. So we have here some case laws, reference to American jurisprudence, search reference, and nothing else here. And we go on generally the nature of fraud. So fraud actions are personal injury actions. Fraud is an independent, willful tort. And fraud in the inducement is an action in tort. Fraud actions are personal injury actions. Fraud is an independent, willful tort. And fraud is in the inducement is an action in tort. There we go. Hey, Deanna Cherie Moore, 2. Welcome. You can sue the four angels 5 times with fraudulent damages. Title 15, fictitious conveyance of language. That paper terrorism, yes. James, we're going to be going over fraudulent conveyance in a soon to cover American jurisprudence. Fraudulent conveyance. All right, so we get all our good people here. Let us continue. There I go. Amjur, there it is. Interact. Fraud is our observation here. I love these in American jurisprudence. Fraud in the inducement and deceit are independent torts for which compensatory and punitive damages may be recovered. Excellent. So fraud in the inducement and deceit are independent torts for which compensatory and punitive damages may be recovered. Although claims of fraudulent misrepresentation rest in equity, fraudulent misrepresentation is recognized as an actionable tort. There are three types of fraudulent misrepresentation, all requiring minimum allegations of misrepresentation, namely reckless misrepresentation, negligent misrepresentation, and deceit. Thus, negligent misrepresentation, like fraudulent misrepresentation, is a tort. Fraud, conspiracy, and conversion are separate torts. Okay, let's look up tort for everybody here that might not know what it means. And give it to you directly from Black, because I might have some extra little tidbits here. Give me a moment to find it here. Jeez, I tortured you so much in this thing. Wow. Tort each. Jeez. There we go. 1654. Oops. Here's. Okay, here we go. Tort. A civil wrong, other than breach of contract, for which a remedy may be obtained, usually the form of damages. A breach of duty that the law imposes on persons who stand in a particular relation to one another. The branch of law dealing with such wrongs. To ask concerning any occurrence, is this a crime or is it a tort? Is, to borrow Sir James Stephen's apt illustration, no wiser than it would be to ask concerning a man, is he a father or a son? For he may well be both. We may define tort as a civil wrong for which the remedy is a common law action for unliquidated damages. And which is not exclusively the breach of a contract or the breach of a trust or other merely equitable obligation. It might be possible to define tort by enumerating the things it is not. It is not a crime. It is not a breach of contract. It is not necessarily concerned with property rights or problems of government, but it is the occupant of a large residuary field remaining, if these are taken out of the law. But this again is illusory, and the conception of a sort of legal garbage can to hold what can be put nowhere else is of no help. In the first place, tort is a field which pervades the entire law, so it is interlocked at every point with property, contract, and other accepted classifications that, as students of law soon discovers, the categories are quite arbitrary. In the second, there is a central theme or basis or idea running through the cases of what are called torts, which, although difficult to put into words, does distinguish them in greater or less degree from other types of cases. So, again, terms of art, a tort, very briefly, a civil wrong other than a breach of contract for which a remedy may be obtained. We'll leave it at that. All right, let's continue here. Oops. Get there, Amjur. There we go. All right. So, fraud, right. Although actual fraud is a tort, breach of fiduciary duty, which may be a component of constructive fraud, is not. Actual fraud is a tort, but breach of fiduciary duty, which may be a constituent or a component, of constructive fraud, is not, a tort. So breach of fiduciary duty is not a factor. A tort. Fraud can be an affirmative defense and may be an affirmative cause of action, so it could work both ways. And looks like we got, yes, sir, we're getting down here to general nature, rational, underlying cause of actions. Okay, so we're going to get on to this for the next one on number 13. Let me write this down with my number 7 Esquire pen and pad of paper. So this is fraud and deceit. And we're writing on section 13. generally nature of the rationale underlying causes of action. We got here, go out to them with the Admiralty Tort Damage Standard, Form 95 under Admiralty Extension Act. It brought the water onto the land. Yeah, sometimes that could work good. You'd have to really have your case well made and be a plaintiff on those kinds of actions for sure, I believe, if that was going to be feasible. But yeah, we're definitely going to be going over fraudulent conveyances. I know you mentioned that one, so we're going to do that, James. And I think everyone's going to enjoy that one. I got some really exciting Amjur stuff coming up, so I want to definitely get on that and keep moving ahead with that. And I really appreciate you all spending your time here with me tonight. I know there's a lot of other things to do on YouTube and other people with live streams, but just you guys being here really shows that you care about our rights and freedoms and preserving this great tradition of American jurisprudence that separates us pretty much from all the other countries of the world and their styles of law. This is centered really around intent of the law to provide for the needs of life, and also to ensure that we have a peaceful existence together and avoid violent remedies for conflict. And also that it's, I see it also as a strength of this nation that we have rights that are upheld and protected for due process, because the system best administered is the best system. So it's a good thing for us to learn these principles, understand the underlying foundations, and then exercise our rights and duties to achieve the proper remedies and corrections that are needed to ensure compliance with this well thought out system when you really break it down to the levels here and shade away a lot of the garbage of statutes and codes and municipal nonsense that has polluted and perverted a lot of the sense of American jurisprudence and common law in this country. All right, with that, I really appreciate the nice statements here too. It's been fun, and it's been fun for me, this whole expedition here with everybody together. So I definitely appreciate everyone coming along. I encourage you all to like, subscribe, hit that bell notification to make sure you hear about the next live stream I do covering this. I always invite the questions and suggestions within the chat here, as we have here. Yes, the veils have been lifted from your eyes, everybody. We're going to break through this and show the proper way to do this so that it can be undisputed as far as our rights being protected and preserve our systems of justice as they were intended to be, to provide for the needs of life and not for life to serve the legal system. On that note, I want to thank you all again for coming, and I will see you all on the next one. Peace out.